Newsfirst, Newsline.
Very good evening and welcome to another edition of Newsline. We've been speaking a lot about parliamentary privileges with the discourse on whether or not judges should be summoned before the Parliamentary Privileges Committee over a judgment that they gave. Recently, the Judicial Services Association also issued a release saying that there are certain factions who are attempting to pit the judiciary against the legislature and create issues in Sri Lanka. To discuss these matters and more, we have with us today President's Counsel S.T. Jayanaga. A very good evening, sir, and welcome to the show.
Good evening.
Sir, just to give some context to this discussion, let's first start off with what is parliamentary privileges. Now, I'm pretty sure all our viewers know that things that are said in Parliament cannot be the subject of a suit in a court of law in Sri Lanka. That is a parliamentary privilege. But on the whole, what are parliamentary privileges?
Yes, parliamentary privileges, if you loosely define them, they are rights which are necessary for the due execution of parliamentary powers. We have an act initially passed in 1953, Parliament Powers and Privileges Act, that sets out what parliamentary privileges are. We are guided by the British House of Commons privileges, but subsequently it has been amended a number of times to say a few of them. Parliament must have freedom of speech. Now that is one. Then also they cannot be arrested. The MPs cannot be arrested, and there is a misconception that they cannot be arrested at all. No, they cannot be arrested for the civil suit, for a civil matter, when they are going out of the parliament or coming to the parliament.
Right.
But for a criminal matter, they can always be arrested.
So that privilege has been brought about to mainly ensure that parliamentarians are present in Parliament.
In Parliament.
Because if not, let's say there's an act that is supposed to be passed in Parliament and the parliamentarian is on their way to vote for the act. By chance, if he gets arrested, then he won't be able to vote for the act. Maybe it swings the other way.
That's right. So then you said at the beginning itself that they can't be sued.
For what they say.
For what they say. Within the well of Parliament.
Right.
So those are few privileges that have been enlisted in the statute. But then for breach of these privileges, there are offences created by the statute itself. Those offences are enlisted in two schedules, Schedule A and Schedule B. Schedule A offences could be punished only by the Supreme Court.
Right.
Schedule B offences could be punished by Parliament and the Supreme Court.
Right.
Either of these institutions. So, if there is a breach of privilege, that person is committing an offence. So, he has to be taken to task. Then the next step is what is the procedure involved? You want me to start that?
Definitely, sir.
Yeah. Normally, when there is a breach of privilege, some member brings it to the notice of the Speaker. Speaker will have to satisfy himself whether there is a prima facie case to refer this matter to Privilege Committee.
But President's Counsel Jayanaga, let's just try and draw parallels with the situation at hand.
Yes.
And the offences that were discussed earlier. Now, in Parliament, a person who is a lawyer himself, Premanatsi Dolevatta, alleged that his privileges or his parliamentary privileges have been violated by this order or this interim order that was issued by the Supreme Court. The Supreme Court in their interim order merely said, release the funds for the election that have already been allocated by Parliament in the budget for the year 2023. So, judging by this, what offence does it really come under?
Yes. Now, before that, shall I
explain the procedure?
Before I come to that, you spoke of offence. Shall I tell you some of the offences that are envisaged in the Act?
Definitely.
Assaulting members, threatening them, sending them threatening letters, trying to bribe them, assaulting or trying to intimidate witnesses who are summoned before these committees. Now, those are the offences that are set out.
Right.
One other offence could be that when a committee or the parliament issues an order summoning a person, if that person disobeys that order, that is an offence.
Right.
Now, that comes under Schedule B. Even Parliament itself can punish that, person. We will come to the punishment part of it later on. Answer your question about this Dolavatta's matter. Now, he merely read out something, brought it to the notice of House. Now, then, Speaker has a duty to ascertain whether this has a prima facie case to be referred to the Privilege Committee. But what did the Speaker do? Over the counter, he referred it to the Privilege Committee. Now, I think that's not correct. The correct procedure should have been, he should have studied this. He should have, there are advisors in Parliament itself, the secretaries. So he must satisfy himself. And then, especially because this is a privilege issue against 3 judges of the Supreme Court. So this will have far-reaching consequences. So he should have been a little more cautious. However, it has been done. Now there is a standing committee, that is the Privilege Committee. So the matter has been referred to Privilege Committee. If I am not mistaken, I think the chairman of the Privilege Committee is Mr. Samal Rajapaksa.
Right.
Former Speaker. Now he must be having a lot of experience. So we will have to wait and see. The procedure is Privilege Committee then summon these judges. If they don't come, they are committing an offence. If they come, they can appear, show cause. They can be represented by their own lawyers. So it will be a kind of a judicial...
quasi-judicial procedure.
Quasi-judicial procedure. So then, if the Privilege Committee might find out that there is nothing in this, and that closes the matter. If they find that there is something, then they report it to the Parliament. Then Parliament by resolution, Parliament must pass a resolution. After a debate, a resolution is passed. That matter will be sent to the Attorney General for his review. Then once he reviews, he finds if there is a privilege has been breached, some offences have been committed, then he will refer the matter to the Supreme Court. That is the procedure.
So the Supreme Court in this matter will be hearing,
Supreme Court judges.
Yes. A breach involving their own members.
Yes, I will tell you. Now, we will come to the punishment. That will be very interesting. Even these matters, Schedule A matters, if they are referred to the Supreme Court, the Supreme Court can punish a person only for a period of 2 years. That is the rigorous imprisonment, 2 years, or fine, not both, or fine. So, if the Parliament punishes a person, Parliament can remove a person from the precincts of Parliament. That is a member of Parliament who is misbehaving within the well of the Parliament. If he is not a member of Parliament, Parliament can prohibit that person from coming into the precincts, coming into the Parliament. Now here in this instance, they wanted the judges to come, if they do want. And if they don't come, what the Parliament can do is ask them not to come. That is the punishment that they can impose.
Right.
So that's a hilarious situation. So if they don't come, the Parliament takes it upon itself to punish the judges. All what the Parliament can do, ask them, don't come, hereafter don't step into our premises. But that's a punishment.
Now, even in the letter that was sent by the Judicial Services Association...
Shalan, can you, shall I read this? That is,
okay.
Since it's interesting.
Yes.
It's very, very...
These are the offences, you mean?
No, not the offences. Offences and the punishment.
The punishment,
Punishment is what is important. What the Parliament can do. Parliament may be, punishment may be imposed by Parliament for any offence under this part shall be admonition at the bar of Parliament or removal from the precincts of Parliament. Provided, however, that in the case of an offence committed by a member of Parliament, Parliament may, in addition to or in lieu of any punishment herein before specified, order his suspension from the service of Parliament for any period not exceeding 1 month. Now, this is what is relevant. Provided further that in the case of an offence committed by a person who is not a member, Parliament may also order that such person shall be prohibited from entering Parliament or its precincts for a period not exceeding 6 months. So, if they want the judges to come, and if the judges don't come, that's an offence. And the punishment that can be meted out by Parliament is asking them not to come. That's it.
So if the situation is really futile, according to what you explained to us, what really is the motive behind this move?
The motive is to scare the judges.
To scare the judges?
Scare the judges. Scare the judges. Tarnish their image. This is even earlier, there were instances where the Supreme Court has set aside cabinet decisions. Declared cabinet decisions null and void.
Right.
Walter's Edge case, for example. Then Vasudeva Nanayakara versus famous insurance corporation case. Privatization of insurance corporation.
The Golface Green case.
That's right, Golface Green case. Now, there were instances where Supreme Court has declared some of the decisions taken by on the basis of public trust doctrine, taken by cabinet,
right,
wrongful, unlawful. So here, what, as you quite rightly pointed out, what the judges have done, that 10,000 million rupees have been allocated by Parliament in the budget for the local government elections, not for Parliament elections. 10,000 specifically allocated for this election.
Yes.
So once that money has been passed by Parliament, that budget has been voted and passed, all what the judges in the interim order says, do not withhold that money. Pass that money to the Election Commission.
Right.
So who has breached? Not the judges, the Treasury Secretary. He is the person now withholding.
Right.
So he has breached the privilege of Parliament. The Parliament has passed this money, and the money is not given by the Secretary. So that shows that Secretary must be taken to task, not the Parliament.
Well, of course, these incidents that have unfolded have really convoluted this entire already quite convoluted election procedure that keeps on getting postponed and postponed. Contempt papers have been filed in the Supreme Court, but when the election will be held is anyone's guess. We'll continue this discussion after a short commercial break. Don't go anywhere. You're watching Newsline.
Newsfirst, Newsline.
Several activists detained by police during Mirihana protest. Anti-terrorism bill to Parliament during third week of April.
තුන්වැනි සතියේ න්‍යාය පත්‍රයට ඇතුළත් කොට දින නියම කර ගැනීමක් කර එයට පෙර ආතුව එම සාකච්ඡා අදාළ අමාත්‍යවරුන්ට ආරම්භ කරන්න පුළුවන්.
UN Human Rights Report urges Sri Lanka to repeal PTA. Kanchana Vijayasekara wants CID investigation on those who tried to sabotage petroleum terminal operations. Trade unions to take legal action against sending striking workers on compulsory leave.
මේ සාමාන්‍ය වෘත්ති සමිති සටනක් කරනකොට සාකච්ඡා කරන්න ඕන වෙලාව තියෙනවා.
Sri Lanka is also facing a significant external financing gap over the IMF program period. Sri Lanka introduces STEAM education system to school.
Newsfirst, Newsline.
Welcome back. You're watching Newsline. We're in discussion with President's Counsel S.T. Jayanaga, and since we have him on the show here today, we'll be discussing a few legal matters, of course, that some members of the general public find a little bit hard to understand, of course, because of the complex nature of these matters, and especially the current situation in Sri Lanka and how the legal system of the country is responding to this situation, and of course how our public representatives are conducting themselves. Let's speak a bit about the Anti-Terrorism Act. Now, there has been broad discussion on the Prevention of Terrorism Act, and for the last 2 decades at least, as far as I can remember at least, the people have been voting in governments, successive governments that came on the promise of repealing the Prevention of Terrorism Act. But as soon as the government comes into power, they take a bite of this forbidden fruit, and they like it. And this Prevention of Terrorism Act has not been repealed ever since it was brought back in the 1970s. It's been in effect for about 40 years now. But now finally, the PTA is about to be repealed. However, the government has proposed in the draft bill to repeal the PTA also, they've included a new act called the Anti-Terrorism Act. President's Counsel S.T. Jayanaga, the PTA is repealed. You've been speaking out against the PTA for a long time. So all is good, right?
Now, I have not made a thorough study of this Anti-Terrorism Act. It is in the bill stage, not even in the bill stage.
Not even in the it's on the Gazette.
On the Gazette. So, but I had a cursory glance. But there are many, many grey areas. I believe possibly it might be worse than the PTA. I will tell you classic example is now the PTA. Personal liberty is a very important thing for any individual. Personal liberty should not be curtailed unless a judicial officer makes an order. Under exceptional circumstances only, personal liberty should be curtailed. But here, that judicial function was vested on the executive.
Has been completely usurped by the executive almost.
Executive taken over. Early under the PTA, now that was vested in one single individual.
The president?
No.
Sorry, the minister?
The secretary. Secretary to the
Defense Minister.
Defense Secretary. But under the new law, a DIG can detain a person for a period of 3 months. And he can extend it up to a period of 1 year.
After produce before a magistrate.
Yes. He may not be, now there is a little bit of a grey area. There are 2 ways of handling a suspect that they take into custody. Straight away go to the magistrate and produce him before the magistrate, then the normal law applies, and the Bail Act also applies. Now, under the Prevention of Terrorism law, Bail Act has no application. But here the Bail Act applies, the magistrate can grant bail, or he can remand the suspect. But if a person is detained, the magistrate will be told about it, and the magistrate will have to regularize that. He puts his signature. Now that's one grey area, has to be sorted out. But I saw something that might affect you all. If some publication is made, some statement is made, some utterances are made, which could be understood by some people or some
section of the public,
or all of the people as an instigation to commit the offence of terrorism.
Or the offence of terrorism as mentioned in the Act.
In that.
Because according to the Act,
it's very wide.
It's extremely wide. It's extremely wide.
It runs to several pages.
Yes.
It's very wide. So now here the danger is there is a subjective element has been brought in. And then this is a very ambiguous provision. A police officer will arrest a person and he comes to court and tells the magistrate, "Sir, I have arrested this person. I am one of those individuals in public. I understand this utterance that was made by so-and-so is an instigation or encouragement
to commit an act of terrorism.
Now that is enough, because some people. So the subjective element has been brought in there. law definition must have a subjective element. It must be precise and objective. But subjective element means anybody can be brought in and pushed into remand.
Right.
There are various other aspects which I have not gone into, but the definition itself is very, very wide. Intimidation of general public. So people who are agitating outside, police can say you are intimidating the people and arrest all of them under the Anti-Terrorism Act. Now, terrorism, we don't have terrorism in this country now. It was, this Prevention of Terrorism law was passed in 1979 for a specific purpose. At that time, there was a civil war going on in the north, only for a specific period of 3 years. But
it's a temporary provision.
Temporary. But it was. I think a lot of international pressure also have been brought to the government. So but this will be debated, I believe, in the Supreme Court. I have a feeling that Supreme Court might knock down some of the provisions. It looks like that.
So also with this act now being brought at a time when the economic situation of the country is down, there are allegations that Parliament is not really representative of the people's mandate, that the President has not been directly elected by the people. So what do you think about that kind of a Parliament, that kind of a cabinet, that kind of a President bringing in an act like this that will prolong this fight against these arbitrary laws in the country?
Obviously. Now, we are just after a public uprising. When there is a public uprising in a country, the best way to settle that uprising is to go for elections and allow the people to choose their representatives. If that was done, all these problems could have been averted. Now here, the government is now slowly, little by little, squeezing. Now anti-terrorism law is being introduced, and now see, they are trying to scare the judges. Highly uncalled for thing. If at all, as I said earlier, the judges have not committed any breach of privilege. So now this is being introduced. So in the present context, I don't know where we are heading for. It's not a healthy situation.
So you said there was a lot of international pressure against the Prevention of Terrorism Act, calling for the repeal of the PTA. So how do you think the international community will respond to this act? Because the way you interpreted it, this act is worse than the PTA.
I think they will be critical. They will be critical. There will be a lot of criticism on this. Yeah, that much I can say. There will be a lot of criticism, except that there is one provision I read. Once a person is taken into custody, his kith and kin must be informed, and his location also must be told to them. And Human Rights Commission also must be informed. So I feel personally, Attorney General must be informed. He must open separate file in respect of each person that was taken to custody under the Anti-Terrorism Act. Eventually, because he will have to advise the government whether to proceed against this person or not to proceed.
Also, President's Counsel S.T. Jayanaga, another huge issue with these people who have been arrested under the PTA is the fact that there are some people who are still in prison, and they have been in prison for 15 to 20 years. That's half of their life.
That's right.
So don't you think it's pertinent to introduce maybe some speedy trial provisions so that these people are not detained for things that they may or may not have done for over half their life?
Yeah, that's true. I think here, of course, it says that even the magistrate can remand him only for a maximum period of 1 year. And the detention order is also limited to a period of 1 year. So I do not know, as you say, whether they should be charged within a specific period. Otherwise, a guillotine is hanging on their head. They don't know where they stand. Either they must be exonerated totally, or they must be charged. So there is no provision like that. So those provisions must come in.
So also moving forward with regard to the prevention of terrorism laws in Sri Lanka or terrorism-related offences in Sri Lanka, do you believe that Sri Lanka needs specific legislation to deal with terrorism, or are the existing provisions in the penal code sufficient to cover all offences?
Well, I have a feeling that the existing provisions are sufficient to cover the present situation, because we don't have terrorism now. We don't have a war, we don't have terrorism, nothing. I mean, we have normal, you know, there can be underworld, that's a different thing. But the existing criminal procedure and criminal laws are adequate. And if they are not adequate, we can amend them.
Also, President's Counsel S.T. Jayanaga, now you've been defending people for quite a long time in courts, inside and outside courts, of course. The Prevention of Terrorism Act, there are many examples where the Prevention of Terrorism Act has been used to arrest, detain, intimidate people who have not committed any form of offence that can be described even vaguely or in any extension of a definition as terrorism. Have you encountered genuine instances where actual terrorists or people who actually committed acts of terrorism have been detained under this act? And usually the detention provision is to prevent harm from coming to the people. Have you encountered such incidents?
Not particularly, you know, I have not encountered, but I have heard that there was a number of encounters like that. People were detained for several years without being charged. So part of their life was taken away.
No, I'm asking people who actually committed or
Yes.
who were actually in the process of committing. Now, we know that in 2019, April 21st attacks, there was ample evidence, there was ample warning given to all authorities across the board. However, the PTA was not used to arrest Zahran Hashim.
I know, that's right. And some people who have been arrested by this Abhisekara was taken away by some other army major. You see, in that incident, some suspects who have been arrested by the police, CID, have been taken away by army, saying that they are army intelligence or they are
Undercover agents.
Undercover agents. So like that, you are quite right. The PTA could have been used in certain instances, but they have not used. And my personal opinion is that we don't need all that kind of harsh legislation.
President's Counsel S.T. Jayanaga, one final question. Our time is almost up. If this act is passed in the present stage, what do you envisage in the future? What will happen?
We will not be able to demonstrate. Demonstrations will be banned, obviously, because I think one act is intimidating the general public. So they can come and say, well, you are intimidating the general public, that's it. And there are certain, quite a lot of grey areas, people will not be able to raise their voice. You know, sometimes raising the voice is not only shouting, but you might have to come out and then demonstrate. Like
And
what
show
happened.
your displeasure.
Show your displeasure. Say what happened 1 year ago. So we all witnessed that, and that has resulted in something. So changed a government, might of the government, a very powerful government was changed. So people will not be able to do that. You know, it will be curtailment of the democracy.
Thank you very much, President's Counsel S.T. Jayanaga. But of course, I think the Minister of Justice also said that these matters can be adjudicated before the Supreme Court, and the Supreme Court will decide. That's your area of expertise, and we trust that you will do right by the people, and of course, also all the other civil activists in the country will also do what's best for the country, along with our public representatives who are supposed to do what is best for the country. Until we meet again, take care and God bless.